Hello, Michigan Realtors, and welcome to a special edition of From the Mailbag. Like many of you, we've been working to interpret the terms of NAR's recent settlement involving broker compensation litigation. In this Q&A, we'll discuss some of the frequently asked questions we've received on this topic. As a reminder, this is a preliminary settlement agreement, and the terms of the settlement are still subject to approval by the court. That means that this information could change, but we will keep you updated as it does. With that, let's dive into that mailbag. Question 1. When do the agreed-upon practice changes go into effect? Again, the settlement is still subject to final approval by the court, but we expect the proposed practice changes to go into effect in mid-July of this year. Question 2. Does this settlement mean that sellers and listing brokers can no longer offer compensation to buyers' brokers? No, it just means that listing brokers can no longer offer compensation to buyers' brokers through the MLS, but a buyer's broker would still be permitted to receive an agreed-upon compensation from both sellers and listing brokers. The seller could agree to pay the buyer's broker indirectly by agreeing in the purchase agreement to assume some of the buyer's obligation to pay, or the seller could enter into a written agreement directly with the buyer's broker. If the listing agent is offering compensation, it would have to be done with the permission and the approval of their seller client. Question 3. Are there any forms available to help buyers and sellers negotiate compensation for the buyer's broker? Yes, Michigan Realtors has drafted a seller concession addendum that's intended to be used alongside the buyer's offer. It allows the buyer and seller to agree in writing that the seller will provide X amount in concessions to be used toward the buyer's closing costs, which would include the payment of a commission to a buyer's broker. Note that this form can only be used if the buyer is already contractually bound to pay the buyer's broker. You can find that form at law.mirealtors.com or in the description box below. Question 4. Is it true that a buyer's agent will need a written agreement in place with a buyer before showing any properties? Yes. The terms of the settlement state that any MLS participant working with a buyer must enter into a written agreement with that buyer before the buyer tours any home. That agreement must specify what compensation amount the buyer's broker will receive and that broker commissions are not set by law and are fully negotiable. Question 5. What happens if the seller and/or the listing broker have offered to pay the buyer's broker more than what the buyer agreed to pay their broker via the buyer's broker contract? In that case, the buyer's broker could not keep those excess funds. The settlement agreement states that if a buyer's broker is receiving compensation from another source, for example, a seller or a listing broker, then that payment cannot exceed the amount that was agreed upon in the buyer's broker contract. As always, thank you for tuning into another installment of From the Mailbag. We know there are plenty more questions to flesh out as we navigate the terms of this settlement, so please send any questions you have to the email listed below. As we work through those questions, we'll continue to make more videos and update our resources on this topic. We'll also be talking more about the settlement and all of its implications at this year's Broker Summit, which will be held on April 3rd in Lansing. You can find links for registration and all other resources in the description box below. As always, thank you for watching, and we will see you next time.